Welcome, HBA members, to our new HBA University live webinar series. We are excited to have HBA company member Fox Rothschild's Real Estate Group kicking off our first educational seminar series geared toward our members' interests. Jay Mankamyer is also an HBA board member, and we thank Rick Rubin and all of the attorneys on our panel for your collective expertise through this platform. But first, a little housekeeping. Please cursor to the bottom edge of your screen. There you will find a Q&A icon that you will be able to use during the webinar to ask specific questions of the panel. Questions will be managed based on time. And now it's my pleasure to turn over the seminar to Rick Rubin. Rick?
Thank you, Cherie. I thought if I put this on, perhaps some of you would think maybe we had Brad Pitt or Dr. Fauci here, and you wouldn't have to look at my face. With all the rules that we all have to comply with that we're going to go over here as part of our panel today. One of them is that we don't have to wear these masks when we are at home or we're not socially distancing. So I'm going to remove it now. And unfortunately, you are going to have to look at me at least for a very short while before I turn it over to my colleagues. We really appreciate the HBA for many reasons. It's a wonderful organization that supports our home building industry here in the metro area and for many, many years, and has helped its membership through good times, and especially times like what we are dealing with today that are rather challenging, interesting, unusual, and difficult. And we thank them for inviting us to participate with you and to kick off your series. Please bear with us. We are novices at doing these presentations from our homes. Although after watching SNL for a couple of their at-home shows, we probably can't do much worse. So we'll do the best we can. I want to thank all of my colleagues who are here with us today and going to provide our various presentations. And Jay Mankamyer, who's on your board, who's one of my partners, put this together with Cherie, and we're very appreciative of that. Jed Sonnenschein, Scott Ross, Spencer Sears, Marcia Picone, Benjamin Morasca, and Joe Sellers. Hopefully you'll be able to take away some interesting information about the law in these times. Be aware that it's dynamic and it's constantly changing. And as we all struggle through this, and we're now actually probably past the first phase, because we're no longer stay at home. We're now safer at home here in Colorado. And even today, the city of Denver has joined the rest of the state, and the metro area has in that part of the process. We'll have to feel our way through this. So there are a lot of legal issues out there. Let's get started in a second. I want to tell you just a bit about Fox. I think most of you know me and a lot of my colleagues. We are one of the nation's largest law firms. We've got almost 1,000 attorneys spread over basically the entire country. I think we have 24 offices now. And real estate is one of our good practices. And it's an especially important one here in the Denver office. And all of you, I think, know that we have been providing services to the home builder community for the last 41 years that I've been in this business. And we will continue to do that. Note that we've got a special COVID site on our website, and you can see that here. If you're looking for general information, and it's constantly updated about the impact and recovery from this coronavirus pandemic that we're dealing with, that's a good resource to click on. So note that. You can see it at the bottom of the screen. We'll show it at the end of the presentation as well. And we thank you all for attending. If you have questions, please use the function on the Zoom. And if we don't get your question today because we might not have enough time, feel free to email us and we'll get you a good answer. And with that, I'm going to turn this over to my colleague, Ben Morasca, who's going to lead off with our first topic. Benjamin.
Thanks, Rick. Thanks, everybody. I think the first thing we're going to go through are issues related to our purchase contracts for land and finished lots. And the first topic I'd like to discuss is the impacts we're seeing with regard to delays in closing, and walk through some of the near and long-term impacts that we can experience with delaying or deferring closings. Right now, throughout the industry, what we're tending to see is that COVID has created, I think, at least for now, more of a near-term concern than a long one. We're seeing many takedowns which were scheduled for the spring or summer being delayed until fall or winter, but at least for now, fewer fall and winter closings are being pushed out. Another thing we've also seen is developers starting to delay construction activities until later this year with the hopes that the activities will ramp back up in Q3 and Q4. The concern there is that delaying construction activity could have some longer term ramifications. As you are all aware, Colorado still needs homes to keep up with existing demand, and the builders need lots in order to construct those homes. If completion of finished lots is delayed for too long beyond the prime building season, an early winter or, God forbid, a second stay-at-home order because of a second wave of COVID later this year could start to affect delivery of finished lots in the longer term. With regard to other delays of closings, though, I think the builder's ability to delay closings if necessary primarily hinges on the language of the purchase and sale contract, and most typically is going to require amendments to those contracts. Contract amendments, as you know, reopen negotiations and can result in builders having to pay additional consideration. But amendments also allow builders the ability to adjust the takedown schedules and other provisions of the contract. Alternative takedown schedules could include acquiring less lots at more closings, delaying upcoming closings, but possibly leaving future closing dates intact. Trade-offs we've seen is that builders are paying increased purchase price on a per lot basis, or the addition of the escalators. It's an opportunity to get creative as you move forward, considering we just really don't ultimately know what the result of this is going to be. If delays are actually permitted under the contract, the builders would typically be required to either pay additional consideration or have a showing that certain conditions of closing have not been met. The additional consideration that may be present in the contract or that you may include in an amendment could include the payment of additional earnest money, or the earnest money already paid becoming non-refundable and accessible to the developer, or even the payment of cash, which may or may not be applicable to the purchase price. Additional, as I stated before, there's also going to be closing conditions in most of your contracts. The common ones being no breaches of reps and warranties, no new exceptions to title. We also often try to include a no moratorium condition as well, meaning that if there's a moratorium by the city or the county on the issuance of building permits or COs, or the availability of utilities, that a builder can delay takedowns until those orders have expired. What we try and do most often is also include in that no moratorium condition a clause that states that if measures exist that preclude commercially viable construction or sale or occupancy of homes, that we can also delay closings. As you're all aware, and as Rick mentioned, we're starting to see things open up now, but I think that the stay-at-home orders and the restrictions on home showings could certainly have been argued to fall within the foregoing provisions. But hopefully, on a moving forward basis, we're not going to see additional restrictions on showings in the future. So I think with regard to delaying closings, I think there's some considerations that should be taken into account. And I think specifically it's your pipeline of lots and how that's likely to be affected by delays of closing, looking 6 months out, 1 year, 3 years out, and whether delaying up to upcoming closings either affects your purchase price or your obligations under the PSAs that you guys are currently subject to. Another issue we've run into and we've been answering questions about recently are cancellation of contracts. While we're not seeing a ton of contracts being actively canceled right now, I do know that we have seen contract negotiations being broken off, being delayed, because as you know, we just don't have a lot of information on a going forward basis what things are gonna look like when we get on the other side of this. There are certain ramifications to be considered with regard to canceling contracts, and those ramifications depend largely on the timing of the cancellation and the language in the contract. If the cancellation occurs prior to the end of due diligence, typically you're going to be able to terminate for any reason and receive a return of your earnest money. Cancellation after due diligence has been waived, the ramifications depend on whether the contract was canceled with or without cause. A with cause termination can occur for a number of reasons. In this instance, a developer's failure to secure entitlements or to complete their finished lot improvements or to satisfy the closing conditions in the contract. If there's cause for termination of the contract, the builders can recover typically all or a portion of their earnest money or other damages. You really need to look at the remedy section in the PSA. The remedy section in the PSA is also going to govern the without cause terminations and the remedies that would be available to your developer in those situations. Most commonly, the developer is going to be allowed to retain the earnest money, and the builder could additionally end up being responsible for additional costs. We've also seen provisions that require builders to assign their architecture to developers in those situations, or even their non-confidential information about the property, which, if it's not specifically included, could be argued sometimes to include certain financial projections or market studies. So it's really important, if you're considering canceling your contract, to know the ramifications of doing so. Another clause that we've gotten questions about in contracts for finished lots involves force majeure issues and the force majeure clauses that you'll find in those contracts. Now, with regard to the lot acquisition contracts, the typical force majeure clause is going to protect the developers from COVID-related issues, but not as likely to afford builders with justifications for delaying closings. If a developer can deliver finished lots, they can deliver the finished lots, and under the force majeure clauses as they typically exist, there's just not going to be a lot of options there for builders. Developers, on the other hand, a number of reasons they could utilize that force majeure clause, whether it's shortages of supplies or labor, government delays or plan approvals or permitting or inspections, you name it, it's really available for the developers to use in those situations. That said, they typically are going to have contractual requirements for how and when they can claim a force majeure. Typically, they're going to have to claim it in writing within a certain number of days after the force majeure event occurs. That's going to be dependent on your contract again and how it reads. Also, the other consideration in the situation we're facing right now is how to calculate the commencement of a force majeure delay for situations related to COVID. I think for government delays, it's probably safe to assume the start date would be the date of a stay-at-home order. The stay-at-home order was issued for a particular jurisdiction. But for other situations, if they were to arise, it's going to be very difficult, and I don't know that we've run into that situation yet, but as home building has been determined to be an essential business, but if we see a second wave, those issues could arise more fully later down the road. Another situation that we've been discussing with clients are land banking contracts, whether they have them or whether they're considering them. And I think the primary takeaway with respect to land banking contracts is just to be careful and know what's in those contracts. There's really no industry standard for a land banking contract, and they can contain complicated provisions that really should be reviewed before execution or before taking action in response to COVID-related issues. They're often very one-sided in favor of the land banker, which under normal circumstances is not that big of a deal. But in the downturn, the one-sided nature of these contracts can end up being very onerous on the builders. Typically, an event of default under one of these contracts, the land banker almost always has the right to retain the lots. But again, I think it's important to review those contracts because there are other substantial remedies that could be hiding in there. Builders could ultimately be liable for the land banker's carrying costs, their legal fees, etc. I mean, you name it. Again, just to stress, just be very careful about what's in the contracts, how they function, and what the ramifications of taking action to delay or defer closings could have under those contracts. Lastly, I want to talk briefly about e-recording and remote notaries. As most of you may know, when the stay-at-home orders began, certain counties throughout the state were not e-recording or accepting e-recordings due to concerns that it was not fair to those without access to e-recording services. That said, currently, as far as we know, all counties are permitting e-recording, which just means if you need to have something e-recorded, you send the original document to the person who would e-record it. They can submit it for recording for the county, and the counties, as far as we know right now, are all accepting those. The other issue I think that's more concerning right now is the remote notarization. On March 30th, the governor issued an order permitting remote notarization of documents, that order was recently extended until May 30th. One thing that's important to note is that not all notaries are able to remotely notarize documents. It's an additional certification above and beyond the standard certificate. So if a remote notary is absolutely necessary, it's important to find someone or have someone with the appropriate certification to remotely notarize documents. A concern that we've heard from title companies is that they're not necessarily in love with remote notarization and may have reservations about ensuring title and reliance on remotely notarized documents. They've all set up clean rooms or drive-up services in order to facilitate closings and to deal with the situations we're now faced with. But if remote notarization is absolutely necessary, the recommendation is just to check with the title company and see what they're willing to accept and what they aren't willing to accept. If remote notarization is absolutely necessary, the certified notary should be notarized using a secure program like DocuSign, and then when the notarization is occurring, you need to use a program like Zoom or WebEx or something similar that has the ability to record audio and video, and then the recording of those recordings are required to be kept for up to 10 years or for at least 10 years. And I think with the state opening up right now, it makes sense wherever possible to utilize other options before using remote notarization. But of course, it's going to be necessary in certain situations. It's just that in those situations, it's just important to know, especially if you're dealing with a title company and insurance issues, whether or not they're willing to accept those. So I would just suggest reaching out before utilizing that service. With that, I'd open it up if anybody has any questions.
Let me add real quick to what Benjamin was saying on the force majeure, and we'll talk about it a bit more as we go through this. It's a tricky topic. There are some equitable doctrines out there if you don't have force majeure in your contract: impossibility, failure of purpose, that you can maybe rely upon as well. You got to look at the clause if it exists. You got to figure out what it applies to. You got to figure out who gets the benefit of it. And many force majeure clauses have all sorts of other bells and whistles on them, like timing requirements, requirements to explain what the impact is, and so on. We've got a letter writing campaign going back and forth right now on a matter that we're working on, where I think there's been 6 letters back and forth between our firm and another major firm in town, arguing over the force majeure clause, the impact of it, because the original letter that we got from them said COVID exists, we have force majeure. They didn't comply with the contractual provision. They didn't do any of the things the contract required for them to do in connection with establishing force majeure, and it's become kind of a real mess as to what exactly is being claimed, what the impact of it is, how long it will extend things for. And so you got to be careful with those things. And what you're going to find with COVID is you don't necessarily know what the impact's going to be, so you may not be able to comply with the contractual provision. So that's a tough situation that we're seeing.
Absolutely.
Any questions? So let's go ahead and move on to our next topic then, and then we can handle questions at the end if people will have them.
Okay. All right. Thanks, everyone.
Okay, now we're going to have Jed Sonnenschein and Joe Sellers. We're going to talk about, we talked about buying by home builder. Now we're going to talk about when a home builder sells, which is home sales contracts.
Good morning, everyone. I'm Jed Sonnenschein. I'm a partner at Fox. My practice focuses on land development and home builder representation. As Rick mentioned, I'm going to handle this next topic with Joe Sellers. I'm going to handle approximately the first 3 items that are up there. And they really all relate to situations where customers or home buyers may want to get out of a contract. The current economic climate is going to cause buyers to get cold feet with respect to taking on the substantial financial obligation and commitment of a new home. For you as the builders, it's not a question of if this is going to happen. I would think it's a matter of how frequently this is going to happen. And I would suspect that there are some of you listening who are already dealing with this situation over the past few weeks. And if you've recently gone under contract with buyers and they are still under their inspection period and have the ability to terminate, then this is straightforward because, as you know, under a typical purchase and sale contract, the buyer has the ability to terminate and have the right to receive its earnest money back. If the home buyer, on the other hand, is past his inspection period, there should not be any viable way for the home buyer to get out of his contract without losing his earnest money, except for a loan contingency or appraisal, and we'll talk about that next. And as you know, in this situation, assuming there's no other out, the earnest money deposit is going to serve as liquidated damages payable to the seller, payable to the builder as the seller. So with that in mind, let's consider a more difficult situation. A customer comes to you and wants to terminate, but he's waived his inspection right, he has no way out of the contract, and he stands to lose his earnest money. The customer is probably going to ask you if he can terminate and get his deposit back. But given the plain language of the contract, you're under no obligation to waive your right to the deposit. And so this situation is more of a business decision and question of diplomacy for you as the builder. You're going to have to consider whether you can entertain the question in the first place, depending upon your leverage, depending upon your financial position. Maybe the buyer has selected options or upgrades that you're already committed to. So your decision will also depend upon the amount of the deposit and also depend upon your buyer. Let's take, for example, the young new married couple expecting their first baby. You may be inclined to work with them and release their deposit to the extent you're able to. On the other side of the spectrum, for the sake of this example, maybe you have a deep-pocketed investor who's looking to get out. You have your reputations and the communities that you're building in. There are a lot of factors that are going to weigh in here, but from a legal point of view, the question is whether or not you, as the seller, want to waive your right to receive the earnest money as liquidated damages. Let's move on to purchaser loan qualifications, including appraisals and employment verification. One of the new realities builders are encountering, and will unfortunately continue to see, is that loan qualifications are now very much at risk. We learned this morning that the unemployment rate is at almost 15%, which is a staggering number. And without diving into the direct effects on the housing market, one consequence of this is that the employment verification required for a buyer to close on a loan is going to present a challenge. You may have buyers under contract losing their jobs and losing their loans, and unfortunately, this issue is not going to go away, especially with all the uncertainty surrounding this pandemic. Appraisals, on the other hand, are probably not going to be an issue in the near term, at least, until and unless valuations start to adjust downward because of the overall effect of the economy driving down product demand and sales prices. At the same time, appraisers may begin to struggle with evaluating all the unknown and the uncertainty ahead when determining their valuations. So, moving back to the employment verification issue, one of the legal issues presented here is what rights a buyer may have if the buyer has waived his inspection and loan contingencies, but before closing, the buyer loses his job and no longer qualifies for the loan. Suddenly, the buyer can't perform because he doesn't have a loan, and as we had discussed, the seller will be entitled to the earnest money as liquidated damages. It's important to keep in mind in this situation, your buyer may have an equitable argument that a third party has made it impossible for the buyer to perform, and the buyer may be able to challenge the builder's right to the earnest money under the basis of an impossibility of performance argument. This is something that's recognized under Colorado law. The defense, it's an equitable concept excusing a party's performance where circumstances beyond the party's control have made it impossible for the party to perform. Applying this principle, a buyer may want to attempt the argument that a pandemic causing large-scale economic shutdown and the buyer to lose her job and her loan was not a foreseeable event under the buyer's control and should excuse the buyer's performance. A situation such as this has not been tested in Colorado. Whether or not a buyer can make an equitable argument like impossibility of performance will depend upon the terms and provisions in your purchase agreement. Impossibility and similar equitable arguments like frustration of purpose can be waived or disclaimed by your buyer in your contract, and that's something that's important to retain. From your perspective as a seller, you should review your contract to see if your loan contingency provision is expansive enough to protect you from this situation, and if not, consider making adjustments to your language. By the same token, to the extent you are not already seeing this, I would not be surprised if your buyers are already looking to extend their loan contingencies. Moving on to earnest money returns. We discussed that the question is going to be whether your buyer has any termination rights remaining that allow your buyer to walk with a return of their earnest, whether that's an inspection contingency or a loan contingency. And if your buyer does not, how you as the builder want to approach this, you want to consider waiving your rights to the deposit. That's what I have for you this morning, and I will field any questions or move this along to Joe Sellers.
So it does look like there's a question.
Okay.
If you look at the Q&A, Jed.
Okay, let me pull it up here, sorry. So my neighbor just picked this time as a great opportunity to start mowing his lawn. So if you hear that.
Yeah.
Okay.
My good friend Bruce Stokes asked, what percentage of deferred PSAs that you are seeing is the seller getting some form of additional consideration? And I think we're going back to the home builder land purchase contracts. But the answer to that is, sorry, dogs, children, phones. The answer to that is, you see that being asked for fairly frequently. and most of those, they don't end up getting paid, or there's some creative stuff being done. I think most of the home builders are taking the position that the economics right now are so upside down anyhow, that to throw more money at a contract in the middle of this crisis doesn't make a lot of good sense. So we're seeing that request probably 100% of the time from developers, but I'd say that we're not seeing it actually being given all that often. But I mean, we're seeing all sorts of various creative ways of restructuring these deals and maybe making more of the earnest money non-refundable, maybe some consideration on the back end. So I don't think we're seeing a bunch of additional money up front, but we're seeing creative ways to deal with that. I think the home builders are mostly taking the position that now is not a time where they can come up with additional funds. We're getting emails daily from our home builder clients asking us how they can defer legal fees, how they can defer other costs they have. So I think asking for more dough in today's environment is going to be a tough. Let's go ahead with Joe Sellers. Thanks, Joe.
Okay. Hello, everybody. I've been tasked with talking about a few related issues here. I'll touch briefly on the force majeure. It's been covered a bit, and some more issues relating to from the home builder's perspective. The first being, what happens if, given the current environment, the home builder wants to get out of a home buyer contract. With these big events like COVID-19 that really lay a body blow on the economy, it's possible that developers or home builders may want to delay, given the uncertainty with regard to market absorption and just all the uncertainty out there. So despite pre-sales, it may just be that the infrastructure outlay and the costs for a new subdivision or a new phase of a subdivision of a project may be too risky in the near term. Most home buyer contracts likely don't have an express out where the home builder can just say, hey, you know what? I decided I'm not going to build the house. I'm going to terminate the contract. There's good reason for that, as we'll see below in a few minutes, because I'm going to touch on the Federal Interstate Land Sales Act that governs a lot of home builders and subdivisions. Rather, the protection for the home builder here is going to be in these force majeure type provisions. And fortunately, the typical home builder contract doesn't commit the home builder to a specific date, at least in the near term, in terms of completing the house, obtaining a CO, and closing the sale. So what can the home builder do? Again, it's relying on these force majeure permissible delays that are in the contract, and most home builder contracts have really good force majeure provisions for the protection of the home builder for this reason, because there's delays. I mean, there's delays with contractors, with subcontractors, with governmental approvals, weather, all those sorts of things that are beyond the home builder's control. So one thing with force majeure, though, is you want to keep in mind that there is an obligation on the part of the home builder. It may not be expressly stated in the contract, in the home buyer contract, but it's going to be implied. There's an obligation of good faith and fair dealing. So you can't just sit and delay because you don't want to finish the project or build the home. You really have to rely on these force majeure provisions in good faith in order to get the benefit of them. Otherwise, you're going to be looked at as proceeding in bad faith, which is not good. so that's really avenue one for trying to get out of a contract or just delay performance by the home builder under a contract. Number two is just good old-fashioned, negotiation with the home buyer. It may be very likely that the home buyer, given the current situation and for the reasons that Jed just touched on, the home buyer wants out of the contract. So they might be tickled if you came to them and said, you know what, we are going to really delay this phase of the subdivision or this whole subdivision project, and we kind of leave it up to you, buyer. What do you want to do? Do you want, if you want out, we'll give you your earnest money deposit back and your upgrades back. And so it may be that both parties agree and that now is not the time. And another tactic here is you could go to the buyer and say, how about, would you be interested in switching to a lot in a phase that we are completing, or even in a neighboring subdivision, if it's not too far away? Who knows? Maybe you just never know. That it may not be likely that a home buyer would agree to that, but it's not impossible. What you want to avoid in these situations is a clear, sort of unequivocal statement that, hey, you know what, we're not going to perform. We're not going to build a house. That's what's known in the law as an anticipatory breach, which could give rise to a default on the part of the home builder. So you want to be careful with that. So moving to the sort of the force majeure provisions, as we've been mentioning, sort of the big issue across the board in the real estate world right now is the topic du jour is force majeure, which are these delays. And Rick briefly touched on this, but a few keys to the making sure you receive the benefit of your force majeure provision is, number one, look really closely at it. Does it reference or contain the epidemic or pandemic is a permissible reason to delay performance? If so, great. If not, all hope is not lost. Typically your force majeure provision will contain sort of catch-all provisions like acts of God, or anything beyond the reasonable control of the home builder. Those sorts of clauses can work here as well. A lot of times the force majeure clause might say that you have to notify the other party within X number of days of the occurrence of the event. It's not uncommon to see a provision that says, you can rely on the force majeure so long as you tell me within 10 days that this has arisen and that I'm going to be delayed because of it. So the best practice here is to communicate the reason for the delay. It may also say, you have to give an estimate on how long the delay is going to last. That's tough in this environment because with COVID-19, there's just so many uncertainties right now. The other thing to remember is that typically a force majeure provision won't apply to just the payment of money. So if construction is delayed just because the home builder is not paying the contractors, that's not going to be in and of itself, that's not going to be a permissible reason to delay performance. So getting a little more specific, the Colorado Real Estate Commission has promulgated what's called the COVID-19 addendum. The Bar Association has a similar addendum floating around out there, and I'm sure lots of the law firms around town have put forth addendums to real estate contracts to specifically deal with the COVID-19 issue. Just briefly to talk about these specific COVID-19 addendums, they really, most of them address two areas. The first one is delay, inability to get services. And that's, this could be for the benefit of the home buyer. The buyer, the lender's not responding, or the lender has said, we're not doing anything for a while, or they can't get an appraisal done, or the title company is shut down for a little while, or there's just so many issues now. On the home builder side, it's sort of the same concept. You might have to shut down your design center for a while. You can't have home buyers coming in and picking out their countertops, their finishes, or you can't get performance by a contractor because of COVID-19. So that's the one area that these addendums cover. The second area is the sort of where the home buyer can't come out and perform because they're under a mandatory quarantine measure. They can't leave their house. So just a couple issues I wanted to hit with the COVID-19 addendum is the thing to remember is the way these addendums are drafted is, at least most of the ones I've seen, it lets you pick a certain amount of time. You say, it lets the parties mutually hit the pause button for COVID-19 by saying, by this delay period for COVID-19, and the parties are free to put in, 14 days or 30 days. And then it says, whatever the deadline in the contract was, if it's delayed, if performance is delayed because of COVID-19, we're going to add 14 days or 30 days or whatever the parties have put in there. The other issue is on the delay because a home buyer can't leave their house because of quarantine measures. Probably one of the best practices is to put in, that the home buyer will seek other means of performing. For example, a mail-in closing, doing a power of attorney, whatever it takes to get the deal done, essentially. So we're seeing that in some of the COVID-19 addendums. What's really important here too on the COVID-19 addendum is to keep it in mind with your other force majeure provisions. As I mentioned a few minutes ago, home builder contracts typically have pretty strong force majeure provisions for the benefit of the home builder. What you don't want to do is supersede that with a specific COVID-19 addendum that, as I just mentioned, has a blank to put in the number of days, where it says, if the home builder can't perform for COVID-19, then the deadline for performance is going to be extended by 14 days or 30 days or whatever the parties put in there. That specific provision is going to control over a more general force majeure provision that's elsewhere in the contract. So you don't want to undo your really broad force majeure provision with a very specific COVID-19 addendum that's going to only give you 14 days or 30 days. That's sort of the landmine there to keep in mind. Lastly, I want to touch on interstate land sales because it's really an important topic in times like these. On the slide here, it says ILSA issues, ILSA. It sounds like a character from a Frozen movie. But what ILSA is, what we're talking about, is the Interstate Land Sales Full Disclosure Act, which is a federal law governing home builder sales of lots in subdivisions of 100 lots or more. That part of it in and of itself is a topic that's beyond the scope for today, because even if you don't have 100 lots, you could, and there's other home builders in there and you're under a common promotional plan, you could still be subject to it, but that's a topic for another day. For now, I'm just going to assume that the home builder the subdivision is subject to interstate land sales. Now, just briefly, what interstate land sales does is it requires the home builder to file a detailed property report with the Federal Consumer Financial Protection Bureau which meets the requirements of the federal act. Now, this is sort of an onerous process, which home builders don't want to do typically, because it's sort of like going down a rabbit hole, and it involves a lot. And fortunately, the act provides some exemptions from having to do that. There's several exemptions in the act, but the one that the home builders rely on, it's really the only practical available exemption for the home builder is it's commonly called the 2-year exemption. And what that is you won't have to file the property report so long as your contracts with your home buyers obligate, and that's the key word, obligate the home builder to erect the home within 2 years after the date that the home buyer has signed the home buyer contract. What's key here is it's really important to note that it doesn't matter that you actually build the home in less than 2 years. What matters is what your contract says. So you can't say, oh, well, we built it in, we'll have it done in a year, so it's not going to matter, or we had it done in a year. It doesn't matter. What matters is what your home buyer contract says. And if your home buyer contract on its face doesn't comply with the statute, then the home buyer has a lot of remedies. I don't want to scare the heck out of everybody, but the remedies are pretty broad under the statute, one of which is the right to rescind the contract at any point up to 2 years after the contract was signed by the home buyer, and that includes post-closing, which means the home builder essentially has to buy the home back from the home buyer. In some ways, this is not the most timely time to talk about interstate land sales, because when there's sort of this, what they call in the financial world a black swan event, when like 9/11 or like the recession in 2008, 2009. What you see are home buyers can use the Interstate Land Sales Act as a sort of a pretext to carry out their buyer's remorse. So in other words, the home buyer wants out of the contract, and there's really no way out other than looking at these interstate land sales issues. And so that's why it's important to have a contract that complies with interstate land sales. I know it's tempting in this environment, given all the uncertainty out there, to not obligate yourself to build a home within 2 years. But keep in mind, you have the force majeure, and under interstate land sales, that's permissible. You can have force majeure. You can have these other equitable doctrine like impossibility, as was kind of briefly touched on earlier. So you're not going to be afoul of the Interstate Land Sales Act if you have in your contract, hey, we may not get it done in 2 years for reasons of force majeure. So that's the much better way to go, and certainly from a legal perspective, that's a much safer way to go, rather than say, oh, well, given this environment with COVID-19, we can't possibly obligate ourselves to build it within 2 years. That is all I have. I know we're time sensitive here, so I'm happy to take any questions or turn it over to the next speaker.
So it doesn't look like we have any other questions on this at the moment, but back to ILSA just really, really quickly. We're shocked at how often we review and we do probably more of this than anyone in the state, review home sales contracts for compliance, that there is no ILSA provision. There's got to be an ILSA provision, and that's beyond the scope of today with COVID, but ILSA does come into play with COVID, because you've got to have your ILSA clause in your contracts so you don't run afoul of that statute. Otherwise, as Joe was explaining, and you do have to have an eye on the 2-year limitation because of the delays you may be suffering with COVID, although hopefully we're not talking about delays that would push you beyond 2 years. And as Joe said, even if it does, you've got other bases to extend the 2 years that are permissible under the federal statute. So if anybody wants to know more about that extremely complex statute, we can talk about it offline. let's move on to our next panelist. So Scott Ross is going to talk to us about another really important issue that we're seeing right now, which is subcontractor issues. Scott, you're on.
Thank you, Rick. My name is Scott Ross. Got a lot to cover here on issues related to subcontracts. I think we should probably just get started given the limited amount of time we have. So let's just kind of power through this. The first thing is we've got here is performance of subcontractors and when performance is possible or impossible under the current requirements. Well, we've got a changing work environment here. So compliance with our public health orders is really what we're talking about here. And that compliance may cause access and scheduling conflicts. It may, with your subcontractors, it may cause the need to reduce the number of workers on the site, or otherwise it cause a decrease in productivity or delays in completion. However, the current guidance does not prevent the construction work from taking place, and so performance is likely possible under the current requirements, but it may lead to delay and trigger force majeure or other remedies. The current requirements include the following. There's the Safer at Home that you've all heard about. That was the governor's executive order that was issued on April 26th. That was accompanied by a Colorado Department of Public Health and Environment public health order, also issued on April 26th. That implements the Safer at Home executive order. As part of the public health order, there is a multi-industry construction guidance, and that is really what is specific to the construction industry. So when we talk about this, we ask ourselves, well, who's got to comply with this stuff? Well, both your subcontractor and the builder has to comply. We'll check the terms and provisions of a typical subcontract here, but it's important to realize, I think, that both the subcontractor and the builder have to comply with this stuff. The builder cannot just wash his hands and say to the subcontractor, it's your baby, you got to make sure that compliance occurs here. I think we're starting to see OSHA a little bit taking the position that they'll hold the general contractors and builders responsible if the subs aren't complying. Most subcontracts will contain provisions on job and occupational safety as well as compliance with laws. And these provisions will typically provide that the subcontractor must comply with the equitable laws and must comply with the builder's job site safety rules and protocols. We're all pretty familiar with that. But in this case, you may find that your job safety rules just don't presently address pandemic safety issues, and they likely do not. So you may want to consider updating your job site safety rules and your job posting with these new rules. And this is where the multi-industry construction guidance can be helpful. So let me take a moment just to kind of briefly review some of those items from that guidance and what it requires. First off is social distancing. We all know what that is. It's required on construction work sites where possible. And if not, as would be the case in some construction activities such as hanging drywall, concrete pours, maybe trench work and similar activities. In those cases, crews are required to employ other measures to limit contact to the extent they can, such as face masks or minimizing the number of people on a work team. So those built into that is flexibility, but there's no hard and fast rule, but the rule does require that you got to do what you can to minimize the exposure here. The guidance requires that you minimize the number of people on a work crew to the minimum number necessary to get the job done safely. It doesn't require you to reduce it down more than that if the job can't be done safely. It requires you to avoid, for the subcontractors, the workers on site, to avoid contact with visitors. For example, if you have inspectors coming in or delivery persons that need to enter the work site, you're supposed to avoid contact with them. There are hygiene measures, such as identifying, cleaning, and disinfecting frequently touched surfaces and equipment, making sure that the worksite personnel wear all standard personal protective equipment that's required for their job, such as eye protection, gloves, reflective vests, and these sorts of things. That may include face masks as well. Finally, there's a component here in the guidance that requires you to worker health be monitored. Workers who are displaying COVID symptoms or who otherwise are just sick simply shouldn't be on the work site. And sick workers shouldn't be allowed back on the site until they've been asymptomatic for 72 hours, or if they're diagnosed with COVID when cleared by a doctor. So that's sort of in a nutshell what the guidance covers. In order to comply with it, you may find you'll need additional safety personnel and inspections, and they may, that may be warranted depending upon the degree of compliance that you're getting from your subcontractors on the site. But again, I think the bottom line is both the builders and the subcontractors are bound to comply with this stuff, and I think we're saying that maybe OSHA is going to hold builders and general contractors responsible for the conduct of their subs on this stuff. So moving on then to our next issue here, canceling, delaying, or putting performance of a subcontract on hold. Well, if you want to do this, the first thing you do is check your subcontract provisions governing suspension or termination of work. Ask yourself how, if at all, does the subcontract address delays, disruptions, interruptions in supplies, or deliveries and similar events. I think you'll find that most of your subcontracts have provisions that deal with this stuff. Most subcontracts will contain force majeure provisions, delay and disruption provisions, change order provisions that permit extension of time and cost adjustments, termination for cause or convenience provisions, and other similar provisions. You should review those to ascertain what events are covered and what events may not be covered, and what are the rights of both the builder and the subcontractor under those provisions. Now, whether COVID-19 qualifies as a force majeure or an act of God under a subcontractor's contract is going to depend on a few things, like the specific terms of the subcontract clause governing the project, and the specific manner in which COVID has affected the project. For example, whether a government or administrative body issued an order halting work or delaying work in some manner, whether necessary materials in the supply chain are delayed or unavailable, whether project personnel are unable or unavailable to work because of illness, quarantine, or other government restrictions on the number of workers that are permitted on the site. All of these things could cause delay here and whatnot. But if any of this arises, again, I think what you first have to do is go back and look at your contract and see what those governing provisions have to say about it. Now, if a subcontract grants the builder the right to terminate the subcontract without cause for convenience, then I think you should be aware that the subcontractor in that case would typically be entitled to be paid for work actually performed as of the date of termination, and the contract may or may not address that. And it may or may not address how unfinished work is to be treated by the builder and the subcontractor. The subcontractor will likely have equitable claims for payment for work done. And so in most of your contracts will probably provide for that as well. But aside from the contractual rights of the builder and the subcontractor, there's a number of issues that I think arise if a builder seeks to suspend or halt the work of a subcontractor before a project is complete. The builder must, among other things, do and cause the following to be done. First, you're going to have to secure the project site from damage. I think that's first and foremost. You got to secure any materials that are ordered or located on or off site. You need to secure the site to protect from public injury. I think we know of several cases where contractors have been asked to leave a job site because of this, and there's been open trenches and things of this nature. Those kinds of things have to be addressed. You're going to have to protect the public from injury and protect the site from deterioration. Again, so that goes to protecting and adequately maintaining all the existing work that is in place. You should probably examine construction completion deadlines required by any lenders that you may have or investors to see if those are being impacted if you decide to put a project on hold. You need to probably also examine all rights and obligations under your other construction contracts and see what interplay you may have between the different contracts that you have with respect to the job. Explore your efforts to minimize financial impacts in any way that you can, if this is going to be the route you go. And then finally, consider what current or anticipated losses may be covered under existing insurance policies. That's a whole nother topic, and I'm not going to get into that at this point. But anyway, if a site or a project is suspended or shut down, then the turnover of control of the site and the responsibility for the site from the subcontractor to the builder will likely involve these kinds of safety and liability issues, as I just noted. If a builder directs that the subcontractor halt work and vacate the site, the subcontractor may respond by disclaiming any liability or responsibility if the sub is not allowed to properly secure or protect its work and materials that are in place. If the work of a subcontractor is suspended, then it may be a good idea to take some of the following actions. You should probably document the physical work that's been completed via inspection and perhaps by video or photo, so that no disputes arise at a later date over what work was completed or the condition of the work is suspension. Also, if the work is suspended by a builder, then verify all inventory of on-site stored materials. You'll want to do this because the builder's insurance may well be applicable to in the event of a loss. Subcontracts will typically provide the deliveries to and the storage at the project or job site are the sole responsibility and the risk of the subcontractor. But if the builder suspends the work, then that risk may very well shift to the builder, which may then require the builder to make sure that those stored on-site materials are insured. Additionally, an inventory would be helpful in the event that payment for on-site stored materials is due to the subcontractor. Again, subcontracts will typically provide that the subcontractor is responsible for damages or loss to all materials and equipment until final payment by the builder, or that no materials will be paid for until properly installed. Your subcontract's termination or delay provisions may address this issue. So again, check your subcontract. But the subcontractor may, in any event, be able to assert equitable claims asserting entitlement to payment for materials stored on site where the builder has suspended or terminated the convenience and taken control of that work site. Finally, consider creating a current schedule documenting the status of all activities at the time of work suspension. So those are some things that maybe you should do if you're going to, or if you're considering suspending or shutting down the site. Okay, so we kind of touched on the suspension or halting of the work. Then what about a restart of the subcontractor's work? Well, the reality here is that most contracts simply don't specifically address a plan for a restart once a delay or shutdown is over, and so a plan will be needed for the restart. So having that discussion early on with your subcontractor is probably a good idea, since you're both in the same boat here, and it will serve as a sign of commitment on the part of the contracting parties. This will allow the subcontractor and you as the builder to make preparation for when the project does restart. Both safety measures and anticipated new measures can be discussed, and how those are going to be implemented. Typical logistical issues can also be addressed. As a builder, if you shut down a site, you may get letters from your subcontractors, as I had indicated earlier. But as a builder, probably the best response you can have to an aggressive claim letter from a subcontractor after suspension that you feel probably doesn't strike the right tone, in my opinion, is probably to pick up the phone and simply have that conversation with your subcontractor. Then you can kind of see if you can find a path forward here. But the builder can then follow up with a responsive letter and striking the right tone while meeting the desired goal here, I think, of reserving your rights and remedies under the subcontract. So see our next issue, changes in pricing and materials for labor due to delays in performance. Let's first talk about changes in material and labor costs. as you all know, subcontracts typically provide the subcontractor will furnish all labor, equipment, materials necessary to complete the work in accordance with the builder's construction schedule, and that the subcontractors shall be solely responsible to pay for all labor, materials, and supplies necessary for the full and complete performance of the work. Now, if a subcontract has a delay and disruption provision, it likely will govern here as to who's going to pay for these costs. It is not atypical that such a provision allocates the risk of increased material and labor costs due to delay or disruption to the subcontractor, unless that delay or disruption is caused by a builder. Now, COVID isn't caused by the builder in this case, so it would delay and disruption provisions would typically allocate that risk to the subcontractor. And those provisions sometimes would limit the remedy to an extension of time to complete. So again, that would, in those kinds of provisions, it would typically be seen that that risk is allocated to the subcontractor. Now, if there are supply chain disruptions, finding and paying for replacement material or even getting the material may be an issue for the subcontractor. But this is really not a risk unique to the pandemic. Supply chain issues arise in many different contexts and in many different circumstances. Again, the terms of the subcontract should probably be reviewed, and as this may fall under a force majeure or other delay or disruption provision, or a change order provision, or perhaps a provision dealing with the substitution of materials. All of these will probably bear somewhat on who holds the risk of an increase in costs here. Costs having to do with compliance with public health orders may result, just compliance itself may result in changes or increases in labor costs. The subcontracts typically provide that a subcontractor must comply with all applicable state, local, federal ordinances, rules, regulations, and these sorts of things. And so in most of your subcontracts, I think we'll find that it obligates your subcontractor to comply with this stuff. And additionally, the subcontractors typically contain a safety provision, a job safety provision. A construction subcontractor in Colorado generally operates as an independent contractor and is typically charged with by the terms of the subcontract for being solely responsible for ensuring that the work is performed in a safe manner in compliance with applicable laws and for adhering to the builder's safety policies and requirements. Thus, I think on the surface, the legal compliance and job safety provisions allocate the risk of increased cost of labor compliance with public health and safety orders to the subcontractor. But on the other hand, the subcontractor could claim that such orders were issued post-contract or were not within the scope of the work bid, and therefore they're entitled to an equitable adjustment in the contract price or the contract schedule to account for work conditions that were not contemplated by either the builder or the subcontractor. This may constitute change in the work or extra work subject to the change order, or it could constitute some sort of frustration of purpose depending on circumstance here. So those are some, I guess the bottom line here is there are a lot of provisions within your subcontracts that deal with disruptions and delays and force majeure and the costs, and allocate the costs of increases in materials and labor. So that's really the first place to start on answering those kinds of questions. There's a few other risks or issues related to delay in performance, which is really the next topic here. We're probably running a little bit short on time here, but I'll go through briefly just a few items. Subcontractor warranties. I think generally warranties apply to completed work and commence when the work or component of the work is complete. So you should be aware that incomplete work may not be subject to any warranty by the subcontractor. So if you shut down the job and the job work is half completed, you may be left with what you get here at that point. Retainage, again, you need to check the contract language. Generally, retainage due to a subcontractor is not due until the work is complete. But if a component of work is complete, work is not to resume, the subcontractor likely has equitable claims to payment of retainage applicable to completed components. If it's a temporary shutdown, again, that's one of the areas that calling and talking with your subcontractors and maybe working through this may be advantageous for both of you, so we get on the same page with respect to some of these items. Again, yeah, I think you have to realize that the COVID is not a situation that is the fault of either of the contracting parties here. And some of these subcontracts do have liquidated damages provisions. And then, of course, those apply if the work isn't completed by the subcontractor within the contract completion time. And these, as you've heard in other presentations before me, these are going to be subject to force majeure or permitted delay provisions and equitable defenses such as impossibility. I'm not going to go into those in any detail, but I think that is a general overview of kind of some of the subcontract issues, and we can move on to our next section here, unless anybody's got any questions or anybody wants to add anything.
Real quick on best practices, what we saw, and this was probably early in all of this, although we're still early in all of this, but in the very early of all of this, where home builders were looking at cash flow issues and making hard decisions and deciding to stop some work. And I think that's probably still going to be ongoing. Think it through before you do it. Think of all the implications, read your contract, figure out what your rights are, what the subcontractor's rights are, and act accordingly. And probably the best practice is if you are going to stop some work and exercise some rights that you probably have in your subcontract to let's stop the work without cause, send a notice that kind of sets forth at least what your position is going to be on a variety of these issues like safety, protection of work, things of that nature. Because what we've seen early on here is some home builders simply ordering work to stop, and then some battles have erupted over you know, how these things that Scott talked about get addressed. And if you in your stop work notice set forth how you want work to be protected, who's going to pay for that, you know, safety issues, things of that nature, I think it'll avoid some kind of nasty back and forth that we've seen so far.
Yeah, I think what you're saying, Rick, is communication is probably key here.
Yeah, absolutely, and in writing's probably better. Why don't we move on to our next topic? And that's going to be employment issues, and Marcia Picone is going to talk about that.
Thanks, Rick. Good morning, everyone. We're going to focus on COVID-19 and some of the issues that might arise in the workplace that you may see as you're moving forward. So as workplaces get up and running, there's a lot to think about as an employer when you're deciding what you need to do and then what you ought to do. Home builders are especially complicated because you have so many different types of workplaces. You have office, the model homes, and the construction sites, and that certainly with the construction sites that Scott has just touched on with regard to some of the rules and regulations. So the purpose of this portion of the presentation is to touch on compliance with the orders, rules, and regulations in the workplace, managing some issues in human resources, and some of the potential pitfalls that you might encounter and some things to think about. So we have a lot to go over, so we're going to just really touch on issues to help you spot issues as you are navigating your way through these difficult times right now. So we're first going to talk about going back into the workplace, and for some of you that would include continuing in the workplace because you have been working for the last couple of months. And so we're talking about going back under the new rules and regulations. Home builders with workplaces in multiple jurisdictions need to be aware that the requirements can be different in various locations. And so you need to consult both state and local regulations and resources as you're putting together your response plan. For example, neither the governor's safer at home order or public health orders seem to require a response plan or a protocol, yet when you look at the Tri-County checklist, that does appear to require a response protocol. Another example is when the state granted Eagle County a variance in late April from the stay-at-home order that was then in effect and allowed Eagle County to implement its own less restrictive public health order. So the takeaway from this is that when you implement a protocol, you understand what the various jurisdictions require. And if possible, if you can implement that plan to include some of the most restrictive regulations and rules, to establish a consistent response throughout your work, your organization in the various workplaces, it's going to be easier to monitor compliance. You're going to have to deal with fewer issues with regard to why does one of your offices have to do something when the other office is doing something else. And it'll be important as the rules and regulations change, so that the guidance is constantly evolving, so you can learn what works and what doesn't for your particular organization. So how do you go about developing the workplace protocol? At a minimum, you should be looking at the public health orders, implementing the safer at home order. And in general, it requires businesses to deputize or to form a workplace coordinator to address the COVID-19 issues. As opposed to perhaps having one person responsible for this, depending on the size of your organization and the different types of workplaces, if you have those. You may consider putting together a task force or a committee that is charged with putting the protocol together and keeping up to date on the ever-changing rules and regulations. So some of these requirements, we've all heard many of them, and but I am going to go through them again at this point. So is obviously you need to maintain your social distancing requirements. You need to clean and disinfect high-touch areas. Need to post signage about good hygiene and make sure that any visitors that come onto your property are well aware of that. Ensure proper ventilation, discourage large gatherings. If you can eliminate shared items, do so. If you can't, you need to regularly clean them. To prioritize your policies that reduce employee density at the work site, such as staggered shifts and remote working options where possible, and provides your appropriate protective equipment, again, depending on the workplace and what you need to do at that point. One of the other requirements is that you implement a system monitoring protocol for employees, such as temperature checks. And where it's feasible, to not do that, you'd have the employees self-report and obviously require sick employees to stay at home. I don't know I don't think that's a question that anyone's going to not implement. So the problem is that there are some very unique issues that arise with the requirement to conduct temperature checks. All employers need to be careful about what medical information you ask your employees, and you must protect that medical information, excuse me, all the medical information, excuse me, that you obtain from your employees. Of course, I'm talking about medical information and on call. And this is except what you may be required to report. First, there are a number of questions that arise under the American with Disabilities Act about what you can and cannot ask employees and how the pandemic affects this. So at its most basic, employers must keep medical information obtained from employees by either an examination or voluntarily disclosed confidential. And employers must not make health inquiries which are disability related. So as you are preparing your protocol or updating your protocol, It's important that your screening protocol be ADA compliant. And frankly, we could probably devote an entire session on that. So happy to answer any questions offline later on if you do have questions regarding that. Second, the employer must appoint and train employees or hire an outside entity to conduct such tests. And third, the employer must provide adequate equipment, personal protective equipment, and data management to comply with the proper screening procedures. And obviously, nothing prevents any employer from going beyond the state's local and state's recommendations. Excuse me. As Scott talked about, there are industry-specific guidelines. I'm not going to go over these because Scott covered them completely. And for those of you with model homes, the public health order allows for in-person real estate showings, but not open houses, so long as the showings are limited to fewer than 10 people. You keep a 6 feet distance between the employees and customers. Any field-based employees are monitored for symptoms, and again, sick employees do not come to work. Gloves and masks are provided, and importantly, you need to keep a customer interaction log for tracing purposes. So this is an idea that whether it is or is not required for your workplace, it's probably a very good idea to keep track of who comes and goes into the workplace and when they are there. It's also important to note that DORA's guidance on the stay-at-home order prohibits in-person showings in open houses. That's not applicable under the safer-at-home order, but in jurisdictions that may have implemented any local stay-at-home orders, you might consider that those prohibitions likely remain, and you'll probably be needing to make that determination on a case-by-case basis. So once a protocol is developed for each workplace, identify a way to monitor it and its implementation, whether that be daily, hourly, or weekly checklists. Again, it's going to depend on your particular organization. You also need to have in place an ability to update the protocol as legal requirements, guidance, and best practices change. Excuse me. Next, we're going to talk about managing employees. It's not something that's unique to the pandemic, obviously. There are a number of human resources issues that arise every day in every industry. But there are a few issues that I would like to mention here, just to have you keep them in mind as you're moving forward. Colorado's an at-will employment state, which means that either the employee or the employee may terminate the employment without notice. But, and you know this all as employers, you cannot terminate employees for unlawful reasons. That obviously goes without saying. But with respect to COVID, there are a couple of issues that have specifically been applied to COVID that I wanted to bring up. First, the whistleblower protections under OSHA that protect employees from retaliation for the employees raising concerns about safety and health condition includes workplaces COVID protections. So obviously, if there is a report, there can be no retaliation against those employees under those existing guidelines. Second, the Colorado Civil Rights Commission recently released guidance interpreting the Anti-Discrimination Act as requiring employers to make reasonable accommodations for employees with a disability that affects their risk for contacting COVID or being harmed if they do contact COVID. Employers are prohibited from terminating or otherwise discriminating against such employees. Finally, under the Federal WARN Act and the Colorado regulations, employers who terminate or furlough for more than 6 months or reduce hours more than 50% may be required to give 60 days advance notice to the employees. But whether how and whether this does apply to your company, and how it applies will depend on how many employees you have, what you are implementing. And so it's important to make sure you review these regulations in light of your particular circumstances, or ask for advice so that you can ensure that you are adequately complying with the regulations so as to not have a problem at some later point. Finally, paid and unpaid sick leave is also provided to employees who cannot work because of contracting COVID, caring for a family member, or caring for a minor child who is not going to school because the school is closed. And these are through the Families First Coronavirus Response Act, the Family and Medical Leave Act, and the Colorado Health Rules. These laws are particularly complicated, and so really beyond the scope of this discussion to be able to go into them at any length. But they raise serious questions for the home builder community. For example, the health rules only apply to certain industries. Real estate and leasing is included, but construction is not. So you will have to review these or seek advice on how these rules will apply to your company as you are going forward. And also don't forget the ADA issues that we touched on with regard to the screening. How am I doing on time, Rick?
I think we're doing okay.
Okay, then the last few points that I want to discuss are the potential pitfalls and liability for employers, and some ideas to consider as you go forward to help manage the risk. Obviously, if you fail to provide a safe workplace, you might be subject to claims for negligence and other types of issues that could arise from failing to provide a safe workplace. So to mitigate some of that risk, develop your workplace protocol based on the legal requirements and best practices. Ensure that it is implemented. It's not enough to just have something in writing. You need to be able to show that you're implementing it and that you're monitoring it and changing it as necessary, and as necessary and as the legal requirements and best practices change. Another issue is to make sure that you are abiding by the relevant labor and employment laws, such as reasonable accommodations for vulnerable populations. You can't retaliate against an employee for COVID-19 performance issues, or obviously, again, under OSHA, as we discussed previously. And if you're not sure about these things, there's a number of resources that you can consult to help guide you through some of the issues. So don't overreach as well with regard to your employees, such as over-intensive and invasive health screenings, or any attempts to circumvent the legal requirements or guidance and best practices. The best you can do going forward is to try to keep up to date on all of the various regulations and keep your employees safe. The last comment I'm going to make is we talked about having to keep medical information confidential that you learn from your employees or that they voluntarily disclose. That's important and required, except under OSHA, you may be required to report COVID-19 in your business. It is a recordable illness, and you are responsible for recording the cases of COVID-19 if the case is a confirmed case of COVID-19 and the case is work-related. The regulations, I won't, in the interest of time, I'm not going to go into any more detail with regard to this. The regulations are pretty clear, and obviously if you've got any questions, we'd be happy to talk with you more about this offline or later on. And that goes without saying for any of the issues brought up throughout this presentation. It's a lot to take in. And so if you have questions, we'd be happy to try to answer them.
So we're going to move along to the next, but real quick,
Mhm.
two quick practice, best practices things for your construction sites. Posting really good work regulations with respect to COVID is an important thing that you should do. Do it in English and in Spanish for obvious reasons, and do it clearly. And also, you need to keep an eye on your subs when they're out on the site, because you are going to probably be held vicariously liable for their failure to comply through OSHA. And so if you see them not complying, either by not social distancing, not wearing masks, not eating lunch together, arriving together, doing any of these sort of things that the guidance say are not good ideas, you should notify them that they need to stop doing that. OSHA is got their inspectors out looking very carefully. They may come out and cite you and expect them to come back the next day and see if you're in compliance. Okay, we'll move on to the next topic. I think that's Spencer. Yep.
Yes, thanks, Rick. Good morning, all. By way of quick introduction, I am a litigator with Fox Rothschild. I've been practicing for close to 20 years, representing home builders and contractors in a wide range of claims, construction and design defects, payment disputes, mechanics lien actions, general property disputes, insurance-related disputes, and general risk management. So generally, I will address COVID-19 impacts as it relates to litigation and claims issues. The first topic I'm going to address is the impact that COVID-19 has had on access to the court systems. Almost all federal and state courts are currently closed to the public, with the exception of certain limited hearings and court appearances that are allowed to move forward. Every major state judicial district has reduced operations in Colorado, most through the end of this month, with some opening on a more limited basis in the next few weeks. Courts in the state judicial system are only allowing in-person hearings to proceed on a emergency basis. And those in-person hearings are for things like temporary civil protection orders, child custody hearings, criminal matters that have a right to a speedy trial or incarceration issues, emergency mental health proceedings. So in short, civil matters, money disputes are not on that list and are not being scheduled currently for or currently allowed to have in-person hearings. In fact, the Chief Justice for Colorado Supreme Court just this week issued a directive extending the court's prohibition on calling any jury trials until July 6th of this year. So while there is a prohibition on in-person hearings and trials that's remaining in place and will continue through at least midsummer, courts are making efforts to conduct certain judicial proceedings, not necessarily trials, remotely by phone or video. Recently, I participated in a case management conference to set case deadlines and procedures with the court and 10 other parties in a large construction defect matter that normally would have been in person, but was conducted by telephone. Other hearings that require witness participation have been done by video via Zoom or WebEx. And most courts do have a WebEx number and an ability to conduct those hearings by video. And so while courts are trying to move matters through their docket to the extent that they can by allowing for telephonic and video hearings, without trials being conducted for close to four months and then inevitably postponed to later dates, the reality is that an already clogged court system will be rendered even more inefficient and time consuming. As it relates to activities, pretrial activities like depositions, those have and can move forward via video. I would caution though, for any of you who are involved in a case, in a litigation matter, to consider and to discuss with your counsel the impact on case preparation in conducting a deposition by video. A deposition, which is questioning a witness under oath before a court reporter, is a very important part of case preparation. In any deposition, a lawyer's goal should be to secure testimony that he or she believes will be beneficial for use later on at trial or to support pretrial motions. And frankly, your ability as a lawyer to secure that helpful testimony can often be aided by the somewhat uncomfortable nature of the deposition itself. Witnesses sworn under oath, sitting in a large conference room with other parties and a court reporter, taking down everything that everyone says word for word is a somewhat uncomfortable situation. And that, in fact, can lead to you securing testimony that you believe is helpful. And a deposition simply does not have the same effect when the witness is not sitting in that conference room with 10 other people and a court reporter, but is sitting in his den on a Zoom video call in his sweatpants. Their comfort level is obviously much greater. To have a large, complex case, or really any matter, strong consideration should be given to whether to proceed or not with case activities, even if those can be done via video, or in the alternative, to seek to postpone the case when current restrictions or limitations are lifted. This concern and the fundamental problem with taking witness testimony via video is amplified if attempted for an actual court trial or arbitration hearing, even if possible to be done by video. As I'm sure all of you know, arbitration is a method of alternative dispute resolution that is certainly here in Colorado more preferable than a jury trial if you're talking about homeowner claims. Arbitrations are typically conducted before a retired judge or attorney with industry experience. And in this current climate, I've had a number of arbitrations postponed that were supposed to be taking place either over the last month or in the upcoming months, had those postponed due to COVID-19 restrictions and limitations. And in some instances, opposing counsel have agreed to the continuance, but in others, opposing counsel have tried to push forward with an arbitration hearing, perhaps thinking they can gain some type of strategic advantage. However, a significant component of any arbitration, just as with any trial, whether to the court or a jury, is how the arbitrator judges the credibility of witnesses, meaning how do they react to certain documents or questions from the lawyer. Facial expressions that a witness gives, looking over to their lawyer or even down to the ground, that can mean a lot for an arbitrator when they are conducting their assessment as to whether someone's frankly telling the truth or not. And so it can be difficult to notice those types of things on a Zoom call or WebEx call, video call, when an arbitrator's attention can be easily diverted, or the witness is simply just more comfortable and able to hide those types of reactions. So each case has its own separate considerations, and everything needs to be looked at on a case-by-case basis. But generally, in advising clients, my advice has been if you can't, obviously, if you're not able to reasonably settle or resolve a matter, and it is in litigation, then I typically prefer to wait to have an in-person trial, depositions, arbitration hearings, as opposed to moving forward on video for those concerns that I've mentioned here. One component of litigation and claims that I have seen video conferencing have worked to some success is mediation. Mediation, which is non-binding meeting of the parties with a mediator to try and resolve a claim short of trial or arbitration. Traditionally, the kind of pre-COVID method of a mediation was the parties meeting at the mediator's office or a lawyer's office, the parties moving into separate conference rooms, with then a mediator shuttling back and forth to each party to address points made by the parties or simply to relay settlement offers. And any successful mediation usually means that the mediator has been able to candidly provide his or her assessment of each party's case privately to that party when the parties are in separate rooms, and then relay settlement offers. And Zoom or WebEx video meeting rooms set up separately for each party with a mediator having access to each separate Zoom call actually do lend themselves nicely to video conferencing and a successful mediation. And it can be, and I've seen it be effective in the past. And so with respect to general litigation strategies in light of the ongoing coronavirus pandemic, it's certainly cliched at this point, but true that the one thing we are certain about is that the future is uncertain. Understanding that many individuals are faced with an unprecedented financial impact that occurred suddenly with little notice. Undoubtedly, both legislatures and courts will in the future potentially take unusual positions or proactive steps in the coming months to avoid recession and frankly to share the loss amongst everyone in ways that contracts written previously simply might not have contemplated. I would not be surprised to see courts more willing to grant home buyers who are looking to get out of their contracts the ability to do so, not strictly on contract language, but under theories of equity and a court's general ability to and discretion to allow such equitable relief. Well, there are court closures and mandates from the Supreme Court to decrease court staff and address most matters on an emergency basis. All litigation activities are not going to be stayed during this time. For instance, the pandemic and court closures are not going to stop the frequent flyer plaintiffs' counsels from asserting construction defect claims. In fact, my experience has been that plaintiffs' construction defect lawyers typically use times of recession as part of their argument to juries and to arbitrators and to courts as to why they should be awarded, homeowners should be awarded, the large repair costs for alleged defective construction, even if for just technical deficiencies that are not actually causing any actual damage. The argument goes that the home and someone's home is an individual's only significant asset, and a homeowner simply cannot afford to pay for the repairs that are needed because of the alleged pervasive construction defects. So we'll still see filing of those claims and efforts from plaintiffs' attorneys to push those claims forward. If you and or your counsel believe that it's in your best interest to try to delay a case and seek open-ended stay of discovery or other proceedings in light of the ongoing pandemic and COVID-19 restrictions, be aware that courts may not be willing to grant a complete halt to all litigation activities. Courts do expect litigants to work together to address logistical challenges created by things, even things like the pandemic and COVID-19 restrictions. I have seen court orders that the COVID-19 pandemic standing alone is not sufficient reason to stay all discovery indefinitely. And to that point, in many cases, it is still possible to collect, review, and produce documents and electronically stored information. Both courts recognize that, and litigants need to recognize that as well. And certainly if there are prolonged delays in any litigation that you do have, that can present its own challenges as it relates to the preservation of evidence issues. And you need to recognize and be aware that certain physical evidence may materially change over during the time of delay. And you need to protect and account for that. For instance, the condition of real property may deteriorate. And to generally mitigate against the effects of delays, litigants need to be mindful of preserving evidence that may be relevant to either the current or future litigation. That means robust inspections, current inspections of locations at issue, taking photographs and video as necessary, moving forward with scheduling evaluation of current conditions by your experts to the extent feasible. Have relevant witnesses write down or otherwise record pertinent details and notes on a claim, as delays, obviously are going to impact witnesses' memories down the road. So those are kind of general litigation strategies and considerations. As it relates to insurance, the most frequent question I hear about is about business interruption coverage and its applicability to COVID-19 and COVID-19 related claims. If you do have business interruption insurance, most policies contain a general exclusion for coverage for a loss caused by what is called microorganisms in most of the policies. And microorganisms is defined to include generally viruses. And at this point, I have yet to see any either national or local case law, Colorado case law, interpreting what and whether the coronavirus would fall into the definition of a microorganism that we see in a typical business interruption insurance policy. However, based on the inclusion of generally of viruses within the definition of microorganisms, it's likely. And so while a lot of policies do contain a general exclusion for viruses, there are policies I have seen, and many policies do, business interruption policies, do contain certain more limited coverages for claims related to losses caused by microorganisms or viruses. Typically, those coverage grants have lesser policy limits than the overall policy aggregate limit. Business interruption insurance, as a general matter, provides coverage for loss of income sustained due to the necessary suspension of your operations during a quote period of restoration. And the suspension of operations must be caused by a fortuitous event that results in direct physical loss or damage to the covered property. A classic example of when business interruption insurance is applicable is, a fire or tornado damages your place of business or a job site, and that results in a shutdown of the business or the work. Business interruption insurance would then pay for the lost income during that time period of shutdown until the physical damage can be repaired and business resumes. I know of examples currently in the metro area of job sites that have been shut down due after a worker that's been at that site has tested positive for COVID-19. And so if your business location or job site is shut down due to someone testing positive or the coronavirus concerns generally, it is likely, and you had business interruption insurance and submitted a claim, it is likely that a carrier would argue that there has been no physical loss or damage to the property that would trigger coverage. And I've seen a number of brokers kind of take that kind of general position when relaying to their clients what they believe the insurance company would do. However, again, each case needs to be considered on its own basis and on its own merits in accordance with the facts specific to that case. There is little uniformity in case law as to what courts would consider, quote, physical loss, and there are certain arguments you could make for coverage. In particular, if you were able to show that the coronavirus-related shutdown was due to someone actually at the job site or even coronavirus being actually found on the premises or at the job site, which rendered the property uninhabitable or shut down, you could argue that this constitutes the presence of the virus at the site or at the premises actually constitutes direct physical loss to the property, and thereby triggering coverage in the resulting under the property, the business interruption insurance, until that virus is contaminated, is remedied, remediated, or eliminated. And there is some precedent in this type of argument in prior situations, in particular situations involving asbestos contamination or gasoline leaks at a property that may not actually be considered property damage, but have led to remediation and repair and triggered the application and coverage under a business interruption policy. And I would also note that many policies also provide coverage for business income losses sustained when a civil authority prohibits or suspends access to a property. Again, that civil authority coverage does require the physical loss or damage component to trigger coverage. So again, it's all claims need to be analyzed on a case-by-case basis. To the extent that you have business interruption insurance and you have potential claims that you believe would fall under or could fall under the policy, I would encourage you to keep track of your losses, what projects or events they arise out of, and be prepared to submit a claim if appropriate. I think we'll move on to Jay now, but I'm happy to take any questions either here or offline later.
Thanks, Jay. Unfortunately, we're pushing Jay to the end with very little time, but Jay, if you could go through the lender issues fairly quickly, that would be great.
Well, the good news is that most of what I had to talk about overlaps with what everyone else was talking about anyway on certain contract principles and best practices, really. So really to the first point on loan defaults and breach of contract, the lesson here and the message that everyone needs to hear is it's going to be dependent on most of the time on what your particular contract language says. Read your loan agreements, read your loan documents to find out where you fall into your performance requirements, what constitutes a default, where you have cure rights, and how the pandemic is affecting your ability to perform those obligations. Obviously there may be certain times where it's going to cause non-payment defaults, but there's other defaults that could arise too, such as scheduling defaults, your construction timelines, things that you agreed to, thinking, oh, this would be a really easy timeline to meet. This is what we want to do. We want to make money. We want to get through these, get through this construction process as early as possible so we can start selling homes. Well, now you're not able to do that. And now it's bringing up not only your problems business-wise, but also defaults in your loan documents. So take a good read or get some help reading those documents to figure out where you stand and what your projections are with not only your current defaults, but what might be the upcoming defaults. And then, besides knowing what those defaults are, knowing what the recourse is on those. There might be certain types of defaults in your loan documents that have, bigger penalties associated with them. There might be carve-out recourse obligations. There might be certain things that are guaranteed that aren't, and while others aren't guaranteed. So, for the most part, if you're looking at, your failure to meet a deadline or your failure to make a payment, you're probably not looking at standard, carve-out recourse obligations. But again, it's worth a read of your documents. Another overlap topic, we're going to skip down to force majeure. It's the same topics that, were talked about by Benjamin, talked about by Jed and Joe. It's another read your documents topic here. There are force majeure clauses in loan documents, especially when it comes to construction loans. When you're talking about the ability to meet those deadlines, a force majeure clause may apply. So understand the force majeure, understand all those concepts that Joe and Jed and Benjamin were talking about, whether it's an inclusive force majeure topic that says it's only these specific items that would give a force majeure excuse, or if it's if it's an exclusive, or if it's an inclusive clause where it says it includes these among others, or it includes the things like Joe said, an act of God, those type of items. And like Jed was talking about earlier, also, if you don't have that force majeure language and you have these obligations that might otherwise relate to the obligations and the inability to perform those obligations due to the pandemic, understand these common law concepts of impossibility or frustration of purpose. These things that might give you those arguments that said, well, even though our contract doesn't say that we have a force majeure delay or that ability to be excused from some performance, we still might have some ability to protect ourselves. So understand that, and understand also if you've waived any of those rights, like Joe was saying. On the workouts, the modifications, and the foreclosures, I'm going to lump those all together for time's sake. And the best way to look at this, and Rick probably knows better than the rest of us combined, what loan modifications and workouts and foreclosures look like in the last recession. And in 2008, it was a different situation. In 2008, it was an economic recession. Yes, it was unexpected. Yes, it was, put a lot of people in a really bad spot, but it was a financial basis of the issues and the problems and the inability for borrowers to satisfy their obligations. Well, this is being treated nationwide, statewide, as not this, this financial issue that, the borrowers could have potentially expected. And there's a lot of, I would say, support from both the national and the state level for the lenders to work with borrowers more so than there was in any previous recession. For example, what I've stated here, this interagency statement. I mean, this is from the Federal Reserve System, the FDIC, the NCUA, the Consumer Financial Protection Bureau, and all the state banking regulators. They all got together and said, listen, we want you to work with your borrowers. We're encouraging it to work with borrowers who are affected by the pandemic, to work out to modify your loans. And we're not going to treat this as troubled debt restructuring. We're not going to make you account for this on your books in a negative way. We're not going to hold you in any lower regard as a lending institution. In fact, we're going to encourage you to do this. So I think that's a big difference from the last recession, is the way that the national government is saying, listen, we want to support these local businesses. And one of the ways we're going to do it is to support the banks who are supporting them. So the lesson here is to work with your banks. They're encouraged to do so. You know, a bank that might have said a year ago, listen, we're not going to talk to you about a loan modification. You know, we're just going to pursue our remedies, is going to have a different message today. You know, it's not across the board, but that's going to be a message that we're going to see a lot more currently. You know, and the same thing with the foreclosures. You know, while that's not part of the interagency statement, the governor's office has issued its executive orders to direct DORA to discourage foreclosures, to discourage, you know, evictions on the tenant side. But the foreclosures applies to both, you know, residential and commercial foreclosures for those businesses affected by the pandemic. So across the board, there is this governmental support to try to help borrowers not lose their property, not get foreclosed out, and to help avoid these defaults. So the message being here, let's talk to your lenders. Let's talk and let's get solutions before you know, this becomes overwhelming to these lenders, and before it's you know, past that point where, you know, they're getting this encouragement. If the economy starts, you know, turning back into the positive side, and everything starts to get to a point where the you know, these agencies aren't treating this the same way, you don't want to have lost that opportunity. If you think that you're going to need a modification, let's figure out a way to do that now, is the message that we're trying to convey. But again, overall, understand your documents, read through, get help if you need it, but read through, understand your clauses on what's a default, what excuses and force majeure clauses are in there, and really what type of defaults you have to worry about as being recourse. So again, I know I cut my time really short, but if there's questions, you're able to reach any of us, and Rick will go through, you know, the closing with all our contact information. But I'm also, you know, on the board. I'm at all the board meetings, so I'm happy to answer questions any other time. So Rick, go ahead and take us home.
Okay, thank you very much, Jay. Just real quick on Jay's topic. The executive orders on foreclosures are time limited, so we'll see what comes up after those time frames have expired. I was talking to a banker yesterday and said, you know, you guys aren't doing much right now other than the SBA stuff. And he said, you're right, but we see a tsunami coming up. And that tsunami is sort of figuring out how we're going to cope with lots of loan defalcations and figuring out how to deal with them. And I think Jay's right. We're going to see something different than the last downturn, which was entirely different, where there were a lot of foreclosures, but a lot of workouts as well. I think we're going to see more workouts this time, and it'll be interesting to see the format they take. I think for a while we're going to see these deferrals they've been doing, but I think as time goes by, they may be, you know, the worm may turn, and they may be looking at other things if we don't pull out of this quickly. So hopefully they'll work with you, but at the moment that's uncertain. Just wrapping it up really quickly, on this last slide, you see all of our names, all of our phone numbers, and our email addresses. We really want to thank the Homebuilders Association of Metro Denver and their university that put this together. You guys have absolutely fabulous professional staff. Cherie and Connie are top notch and have done a great job. We really enjoyed working with them, and I think they put this together very quickly and in a really good way. Hopefully we've given you good information. We've kind of the tip of the iceberg because there's so much going on right now. And again, if you want any other information, please feel free to contact us. We're not as busy as we normally are, so we're happy, except Spencer. Litigator's pretty busy right now, but the rest of us, work slowed down. You guys know as well as we do that, you know, the industry's retrenching a bit at the moment, trying to figure out where it is and where it's going. We appreciate our long-time relationship with the home builder community in this state. We're probably the largest group of home builder attorneys in the state. Scott and I were counting the other day, and I think we probably do over half the declarations, for example, that are prepared in the state. So you guys have been great to us, and we love our relationship with you, and we're happy to help the industry in any way we can. We wish all of you good health. Please be safe. And we're hoping, they say men can cry nowadays. we're hoping for a strong return to robust business. So on that note, I'm going to turn this back over to Cherie. And we thank our panelists. You guys did a great job. I'm going to say that myself. And we enjoyed doing this, and we'll do another one for you guys, hopefully on recovery.
Well, thank you so much, Rick, and thank you, Jay, and thank you to the whole panel. You can tell it's allergy time. We're all struggling with that, but we appreciate all of you that have attended. This is a lot of terrific information that we've heard that a lot of you are very interested in and wanted to know more about. So this powerful panel provided, as Rick said, the tip of the iceberg. We will be providing this as a link on HBA. If you look to www.hbadenver.com, you can go back and utilize this as a resource. So thank you, members. Thank you, Fox Rothschild, and thank you to Connie Dell for the all the work in getting us up and running. So thanks, everybody. Bye-bye.